The clock is ticking. Right now, as you're watching this video, there's a 30-day window that could determine the future of gun rights in America for decades. And most gun owners have no idea this is even happening. On November 8th, a federal judge struck down Illinois assault weapons ban in a massive 168-page ruling. But here's what the media isn't telling you. That ruling was put on hold for 30 days. The state appealed immediately. And what happened during those 30 days, what's happening right now in the courts, will decide whether you get to keep your 15, or whether gun bans spread to every state in America, if you own firearms, if you care about the Second Amendment, or if you've been watching these court cases wondering, what does this mean for ME? You need to watch this video to the very end, because I'm going to tell you exactly what's happening, what the timeline looks like, and most importantly, what you need to do right now. Let's get into it. Hey everyone, welcome back. I'm Your Name, and if you're new here, this channel exists for one reason: to keep you informed about your Second Amendment rights without the political spin, without the fear-mongering, and without the BS, just facts, analysis, and action steps. Before we dive in, do me a favor, hit that subscribe button right now. Here's why. This story is moving fast. The appeals process is happening as we speak. And if you're not subscribed with notifications on, you might miss critical updates that could affect your rights. I'm going to be covering every development in this case, and you need to be here for it. All right. Let's talk about this 30-day window, what it meant, what happened, and where we are now on November 8th, 2024. Judge Stephen McGlynn issued a permanent injunction striking down Illinois assault weapons ban. It was a huge victory. 168 pages of legal reasoning saying this law is unconstitutional. The state cannot enforce it. But, and this is critical, Judge McGlynn included something called a stay in his order. A stay is basically a pause button. He said, my ruling will take effect in 30 days. Why would he do that? Simple, to give Illinois time to appeal. And Illinois wasted zero time. Attorney General Kwame Raoul filed a notice of appeal the same day the ruling came out. Not the next day. Not a week later. The same day. So here's what that 30-day window meant. Illinois had 30 days to ask the higher court, the Seventh Circuit Court of Appeals, to block Judge McGlynn's ruling from ever taking effect. And on December 5th, just days before the 30-day window was about to expire, the Seventh Circuit granted Illinois' request. They issued a stay keeping the ban in place while they review the case. Let me be clear about what this means. Judge McGlynn's ruling is still valid. The Seventh Circuit didn't overturn it. They just said, we're going to keep things as they are with the ban in place while we figure this out. Dan Eldridge, president of Federal Firearms Licensees of Illinois and one of the plaintiffs in this case, called it predictable. We expected this, he said. The question now is, what's the Seventh Circuit going to do when they actually hear the case? So the 30-day window closed. The ban is still in effect. What's next? This is where things get technical, but stay with me because this is important. After the Seventh Circuit issued the stay in December, the case entered what's called the briefing phase. Here's how appeals work. Both sides submit written legal arguments called briefs. These aren't short documents. They're comprehensive legal arguments, laying out why each side thinks they should win. The Seventh Circuit set a schedule, and this is where we are. Now, states brief. Illinois had until May 7th, 2025 to file their opening brief arguing why the ban should be upheld. Plaintiffs' brief. Gun rights groups had until June 6, 2025 to respond, arguing why Judge McGlynn's ruling should stand. States. Reply. Illinois filed their final response by June 27, 2025. And as of TODAY, December 11, 2025, all the briefs have been filed. The written arguments are done. The court now has everything it needs to make a decision. So, what are the two sides arguing? Illinois is saying A-15s and similar rifles are military weapons. They're offensive and militaristic. They're not commonly used for self-defense, so they're not protected by the Second Amendment. Gun rights groups are saying these are the most popular rifles in America. There are 24 million AR-15 style rifles in circulation. They are commonly used for self-defense. Judge McGlynn got it right. They're protected by the Constitution. Who's going to win? That depends on the 3 judges on the appeals panel, and we'll talk about that now. Here's where things get complicated and, honestly, a little frustrating for gun owners. While the Illinois case is moving through the 7th Circuit, the Supreme Court has been weighing in on similar cases from other states. And the news hasn't been great. In June 2025, the Supreme Court declined to hear challenges to Maryland's assault weapons ban and Rhode Island's magazine capacity ban. They just said, "We're not taking these cases right now." 3 conservative justices, Thomas, Alito, and Gorsuch, said they would have taken the cases. They wanted to address this issue, but they needed FOUR justices to agree. And they only had 3. Justice Brett Kavanaugh wrote separately saying he thinks the Supreme Court should address the AR-15 ban issue in the next couple of years. Not now, but soon. What does this mean for the Illinois case? Here's the reality. If the 7th Circuit upholds the ban and sides with Illinois, gun rights groups will appeal to the Supreme Court. And based on what happened in June 2025, there's no guarantee the Supreme Court will take the case. But here's the thing, right now, different federal courts are reaching different conclusions. The 4th Circuit upheld Maryland's ban. The 1st Circuit refused to block Rhode Island's ban. But Judge McGlynn in Illinois struck down a similar ban. This is called a circuit split, and the Supreme Court loves to resolve circuit splits. That's one of their main jobs, making sure federal law is consistent across the country. So, if the 7th Circuit reverses Judge McGlynn and says the ban is constitutional, we'll have a clear split. Some courts say these bans are fine, and at least one judge says they're unconstitutional. That increases the chances the Supreme Court will have to step in. Alright, enough background. Let's talk about what you need to do right now, because this isn't just about Illinois. This is about setting precedent for the entire country. Action number 1. Know your state's LAWs first. Know where your state stands. As of right now, 9 states have assault weapons bans. California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, and Washington. Plus Washington, D.C. If you live in one of these states, the Illinois case directly affects you. If you don't live in one of these states, don't get comfortable. If Illinois ban gets upheld, other states will follow. Go online right now and look up your state's current gun laws. Know what's legal, what's restricted, and what's under legal challenge. Action number 2. Support gun rights organizations. This isn't a sales pitch, this is reality. Court cases are expensive. The plaintiffs in the Illinois case, gun shop owners, gun rights groups like the Firearms Policy Coalition, the National Rifle Association, and individual gun owners are spending hundreds of thousands of dollars on legal fees. If you care about this fight, put your money behind it. Pick an organization you trust: FPC, NRA, Gun Owners of America, your state rifle association, and support them. Even $10 a month adds up when thousands of gun owners do it. Action number 3. Stay informed and VOCAL. This case is going to result in a decision sometime in the next few months. Maybe weeks. Maybe longer. But when that decision comes out, the media is going to spin it. Politicians are going to react. And your voice needs to be part of that conversation. Follow credible sources for updates. Subscribe to channels like this one that break down legal developments. And when the time comes, contact your elected officials. Let them know where you stand. Action number 4. Don't panic buy, but be strategic. Look, I'm not telling you to go out and panic buy firearms or magazines. But here's the reality. If the 7th Circuit reverses Judge McGlynn's ruling and upholds the ban, it's going to embolden other states to pass similar bans. If you've been thinking about purchasing a firearm that might fall under future restrictions, now is the time to make that decision thoughtfully. Don't panic. But don't wait until it's too late either. Action. #5. Educate OTRs. Most Americans don't understand these legal battles. They hear assault weapons ban and think, sure, why not? because they don't know that AR-15s are used in a tiny fraction of gun crimes. They don't know that 24 million Americans own these rifles. They don't know that they're commonly used for home defense, hunting, and sport shooting. Have conversations. Share videos like this. Educate your friends and family. Change minds one person at a time. Here's what a lot of people miss. This Illinois case is one battle in a much larger war. And right now, we're at a crossroads. The Supreme Court's 2022 Brune decision was supposed to change everything. It set a new standard. If you want to restrict guns, you have to show there's a historical tradition of that restriction. States can't just say it's for public safety anymore, but here's the problem. Lower courts are ignoring Brune, or they're twisting it. The Seventh Circuit has already shown they're willing to keep these bans in place. Other circuits have done the same. The Illinois case is a test. Will the courts follow Brune, or will they find ways around it? If the Seventh Circuit reverses Judge McGlynn, it sends a message. Brune doesn't matter. We're going to uphold gun bans anyway. If the Seventh Circuit upholds Judge McGlynn, it sends a different message. Brune is real. Commonly owned firearms are protected. States can't ban them. And eventually the Supreme Court is going to have to weigh in. The question is, when? Justice Kavanaugh said, in the next couple of years. That's vague, but it suggests the court is watching. They're waiting for the right case. And the Illinois case might be a dot, so here's the bottom line. The 30-day window has closed. The case is now fully briefed before the Seventh Circuit. A decision could come any day now, or it could take months. We don't know, but what we do know is this. Gun owners can't sit on the sidelines. This case matters. The proceeding it sets matters. And your voice matters. So here's what I want you to do right now. Hit that like button if you found this video helpful. Drop a comment below and tell me, do you think the Seventh Circuit will uphold Judge McGlynn's ruling, or are they going to side with Illinois? I want to hear from you. And please subscribe to this channel and turn on notifications. I'm going to keep you updated on this case every step of the way. When the Seventh Circuit issues their decision, you'll hear about it here first, with clear analysis of what it means for you. Thanks for watching. Stay armed, stay informed, and stay ready. This fight is far from over, and we're going to see it through together. I'll see you in the next one.